Hi, everyone. This is David Slang from SNC. Wanted to welcome everyone to this webinar, which is the third in our series on navigating the COVID-19 crisis. First of all, thank you for joining and hope everyone who's dear and near to you is all safe, healthy, and well. This is a challenging time. It presents some challenging questions for us. It presents some challenging opportunities for us. And we're here to join with you to have this conversation. Joining me on the panel are my colleagues, the head of our tax group, Ron Kramer, maybe you can raise your hand, Gautier Blanc-Liuet, who is resident in our Paris office, who has seen some of the most exciting cross-border transactions recently, and last but not least, my colleague, David Spitzer, who is an expert in many interesting cross-border M&A capital markets transactions. So with that, we will kick off. I think everyone has received a slide deck, which will accompany our conversation, but we will not probably slavishly follow it. To start off, let me turn to Ron. What are your global thoughts about this crisis, and maybe lead us into thinking from a tax perspective, what's different about crisis from other crises we have experienced before?
Well, thank you, Davis, and thank you all for joining us. I do think that a lot of the lessons that we learned in prior downturns are applicable, so that some of the M&A conversation we're shortly going to have is similar. I think to the extent that there is a further downturn, it's not simply a liquidity crisis, but it's a longer crisis, then that has economic consequences which have tax consequences. But I think that many of the things that we'll be talking about today are the kinds of counter-cyclical tax issues that we have faced in the past and are now facing again.
And one of the things, Ron, presumably when you're talking about the something that's common to earlier crises is the utilization of losses, because presumably more companies are going to have losses, and there will be tremendous interest in knowing how to utilize them. And David, maybe you can start us off on how you are thinking about that question.
Sure, thank you, Davis. So I think to a certain extent, the utilization of losses is not something obviously that's unique to this crisis. But I think our expectation is, and to a certain extent, we're already seeing, this phenomenon is that the extent to which this is an issue is more significant, both in terms of the size of the losses and the extent to which the losses are spread among various taxpayers. So, for example, one phenomenon again that is common to, say, M&A transactions is a discussion or negotiation between buyers and sellers in trying to understand how to value tax attributes that the seller has. And the implications of this crisis are in some ways make those discussions easier, and in some ways make those discussions far more difficult. So, for example.
So David, for instance, suppose that you're a seller and I'm a buyer, and you come to me and we've done a deal for the basic business. And now you tell me, oh, by the way, there's this NOL carry forward that you're going to get. Can you please pay me for that? Oh, and by the way, also it might be increased because there are transaction deductions for this transaction, which are going to also flow into your period. And so pay me for that. So, how does the negotiation go then?
Well, a lot of it begins or starts with the deal dynamics, which is, is this, is this part of an auction process, or is this part of a separately negotiated process? So in an auction process, at least what I've seen is, not surprisingly, the seller goes out and says, we want you to pay us for our tax attributes, and as you said, for any attributes created as a result of transaction-related expenses. And by the way, we want you to pay us just upfront based on our current effective tax rate of say 26%. And so, what those discussions don't really take into account, or what the 26% really doesn't take into account, are both the impact of the transaction on the seller's ability, or on the target's ability to use those attributes, and potentially what other attributes the buyer has.
So just to pause you, so I mean, if I'm the buyer then, and you ask me that, I would say, well, look, didn't the CARES Act just allow you a 5-year carryback? So I don't want to deal with all this stuff. You deal with it. Go to now I remember you've had losses for 6 years. So these losses are worthless to you, okay? And you're asking me to pay for them. Why am I going to pay for them? And so I think this goes back to the deal dynamic, which is if I'm the only game in town, I can drive a pretty hard bargain now.
Well, I think, I'm sorry, Davis.
Go ahead.
Yeah, so I think to a certain extent, Ron, a lot of these discussions revolve around deal dynamics and who has a leverage in a particular transaction. At least I think what I'm seeing, and perhaps not altogether surprisingly, in the last several weeks, a lot of the transaction leverage posted sellers, not necessarily the easiest time to get a deal done. But I think the two elements that you have are number one, getting an understanding as to what the attributes are and what limitations will apply to those attributes, and to a certain extent, the ability of the buyer to utilize those attributes. And there are really, I think, a couple of circumstances that are particular to a buyer that can impact that. So one is, does the buyer otherwise have tax attributes that it would have been able to use? So I think in the current environment, I think it will be more common perhaps than it was in the past that a seller will have tons of losses, but so will the buyer. And so the question is, do the seller's tax attributes really add value to the buyer?
Right. So Davis, are we okay you can jump in? I'm sorry.
Well, I think one of the questions about value, David, that I do think that we need to ask is, as tax lawyers, we are used to really thinking about the cash taxes. Mm-hmm. And what is the amount of cash value from the losses that would actually reduce taxable income. But of course, buyers and sellers have different constituencies, and one constituency is the reflection of these losses on financial statements. And Gautier, I know that you have given some thought to that question on how that financial statement impact would impact how people negotiate losses, especially in this environment.
Yeah, no, absolutely. And this discussion has also a translation in the financial statements, and this is going to be an immediate issue in the 2020 interim reporting period. Even outside the scope of a deal, and here in particular, the issue with respect to deferred tax assets, which are generated by unused losses or unused credits, and which have to be booked in the financial statements because they reflect potential tax savings in the future. This discussion about deferred tax asset is going to be clearly impacted by the crisis. The amount of DTAs reflected in the financials are going to be affected not only because of the changes in the company's projection of forecasted cash flows and income, but also because of all the legislative changes which is currently going to affect the future taxable profits of the company. Also, reliefs, reduced tax rates, relaxations of rules governing the use of losses. All this is going to have an impact on the way companies are going to value deferred tax assets, and also changes in the strategy of a company might also have significant impacts. For example, a revision of the company's plan to repatriate distributable profits. So the question is wider than the pure, M&A context, obviously.
Can I jump in on that, Davis, if you don't mind? Which is, I think that this, you might think that the seller, in the beginning part of the conversation, the seller was having a hard time because David and I were about to have a conversation to say that the buyer's use of the losses was going to be pushed out in time a lot. And therefore, there was going to be a difficult present value conversation about what the losses were worth. But Gauthier's point is interesting because if your scorekeeping metric is not cash tax, but is financial statement tax, then it's really the reflection of the deferred tax asset, and timing differences don't matter that much unless they cause the asset to fall off. And so the present value conversation may, to some extent, get taken out of the picture if the metric is agreed to be financial statement taxes. And that helps, I think, the seller in this context, because otherwise the seller is going to have a hard time.
That's true. I think there are some factors such as, the impact on financial statements, which may assume away some of these contingencies. On the other hand, I think financial statement would have to take into account some of the other contingencies, which may be very difficult to evaluate. If you're like me, I am checking the website for the Johns Hopkins University model, the University of Washington model every day, and these models change. So they have different projections. And imagine to layer on top of that tax projections and income projections based on projections about a pandemic that no one actually right now has certain knowledge of. And on top of that, Gautier, to your point, to layer a level of prognostication about future legislative change, I think that makes it tremendously difficult to actually arrive at a very high level of certainty about the present value of these attributes. So I throw open to the panel, do you think that in this time we could see an increased use of things like contingent value rights or tax receivable agreements to close this gap, which is obviously not particular to this crisis, but maybe of particular interest in this crisis, given the nature of what it is?
Well, I'll start. I think that's a very good question, and I wouldn't be surprised if you see a movement in that direction, in the sense that tax receivable agreements, for example, are a technology that people use in order to both have that's intended to allow the parties to capture the value of tax attributes in connection with the transaction, typically on it's done on a with or without basis, so that the parties are sure that from the buy side you're not paying for tax attributes that you're not using, and from the sell side you're not being kind of underpaid for the use of their attributes. At least in theory. It's a little more complicated than that in practice, but having the ability to kind of have a long stream of payments that kind of track the actual tax savings from those attributes, at least in theory, I think does bridge some of the gap on the uncertainties that you've mentioned.
Yeah, and particularly the conversation that David and I were going to have, the negotiation, buyer and seller, where the present value discount rate was going to be a very, very tough thing for us to agree on. because as the buyer, I was going to argue for a high discount rate, and as the seller, David was going to argue for a low discount rate. Here it doesn't matter because we wait and see what actually happens in the future. And when I, as the buyer, receive the benefit, absolutely positively to my satisfaction from the government in the form of lower taxes, then I pay some percentage of that benefit back over to David, the seller. And I don't have to worry about that negotiation anymore. So I think it does bridge a gap, I think.
Right, and just to remind everyone, tax receivable agreements are probably most commonly and famously used in the context of Up-C structure IPOs, where sponsors believe that the public would not value the tax assets correctly, and so they interpose a tax receivable agreement into the structure so that particular value can be explicitly separated out and valued and be down to the benefit usually to the sponsors with some allocation to the public as well. I think in this context, when you're talking about not in an IPO structure, but in a buyer-seller structure, David and Ron, I think one potential cloud to the silver lining perhaps is that this would force people to live with this for a long time, that there is a complexity. The tax receivable agreement solves some complexity such as PBing and the speculative nature of this crisis and this pandemic and income projection, to go to his point, financial and legislative change, but it adds its own complexity, such as the longevity of the relationship between seller and buyer.
I think that's inarguably right, at least in theory. One of the horror stories sometimes I like to tell to kind of inform some of the decision making in the context of particular deals was a situation where that I was involved in, which was essentially dealing with the tax attributes being shared between buyer and sellers more than 30 years after the transaction had actually taken place. And nobody was willing to kind of close the books on it and move on. So, these transactions have the potential, or these arrangements have the potential to keep the buyer and seller, attached at the hip for quite a long time. There are ways in tax receivable agreements, it is common, in the context that you mentioned, Davis, in Up-C Corp or IPO transactions, for the company to have the ability to close out the tax receivable agreement, essentially by buying out the holders of the rights for any remaining tax attributes based on a certain set of assumptions. But to a certain extent, that's kind of you have the same decision process that you've kicked down the road. So I think there are ways to close that out, but if there are significant attributes, I think you probably are going to be living with this arrangement for quite a long time. Go to Adana, were you about to add something?
Yeah, no, sorry. I was just going to add that there will be probably another area which might generate nervousness in the negotiation, which is going to be the level of the impairments and the policy that the seller will have applied during that period, because with very high level of impairments might generate costs associated with future reversals of impairments, and so in this period, in particular for assets which are measured at fair value, what is fair value in the current circumstances, and is it possible to come up with a sort of reasonable number given the market volatility, and so we can certainly predict a pretty close scrutiny by all sorts of stakeholders, including investors, creditors, and also potentially the tax authorities, raising risks of tax reassessments for those impairments which give rise to a significant tax deduction.
And in addition to the buyer-seller dynamic and the difficulty of valuing these attributes, for companies that are committed to going their own way and not wanting to accidentally fall into an ownership change which affects NOL utilization in the US, and Gautier, I understand also that's a common feature of the laws governing the use of attributes in many other countries in Europe. Perhaps companies can start thinking about adopting tax asset protection plans, which I think are becoming increasingly popular in this context. Ron, do you?
Well, yeah, I mean, I think that these 382 pills, they're certainly going to be front of mind for people. And to translate this out in the world, the change in ownership that triggers a 382 limitation is a very artificial construct. It's sort of a change of control, but it's very baroque in its application. And so whether you have a change of control under 382 might be very different than whether you have a German change of control limitation or something like that. But that being said, I would sort of throw it out to this group that is now the time for just everyone to en masse adopt 382 pills, even if you don't have any NOLs right now, because NOLs are probably coming. What's the downside?
Well, I'll take a stab at that. I think the downside largely is, not really from a tax perspective, but from an investor perspective. 382 pills, in addition to serving as protection against an ownership change, also have the effect as an anti-takeover provision, which is frowned upon by certain members, by the ISS types and activist members. Activist investors rather. And, so I think, at least in my experience, companies that historically have adopted these pills have been one both with, not surprisingly, very significant tax attributes, but also, I think, given, to borrow your term, Ron, the baroque nature of the 382 tests, which look at, cumulative changes in 5% shareholders, already have some significant level of ownership change. So, I think people would have expected a company that is, that has an ownership change of, somewhere in the 40s, to adopt a pill to make sure that their attributes are protected against, even if there's one more 5% holder, it could cause them a problem. You would certainly expect a company in that circumstance to protect it. But companies that have had a de minimis amount of cumulative ownership change, you would not have expected them to do so. At least what I've seen, picking up on your theme, Ron, in the last few weeks, is companies that have that either have or expect to have significant tax attributes, considering adopting these pills, even if they haven't had what one would normally consider a cumulative change. And part of the expectation is that, the investor community, I think, will become more inured to the notion that companies need to take these steps.
Yeah, and maybe, Davis, just one addendum there, which is, it goes back to your first question, which is, why is this crisis different? It may be the ability to jam a lot of things in that otherwise would have caused people to scream, but now, you just do it and nobody cares. So this may be one of those examples.
Well, I in fact, that was the point that I wanted to bring up, which is that obviously, people might think about adopting 382 pills earlier than they otherwise would in the life cycle of a company, in part because this pandemic is so uncertain and there are so many unknowns about it. And it's more difficult to time and optimize the timing of the adoption of such a pill And why not, in fact, engaging some prophylaxis to prevent a loss that is coming up from being subject to limitations. Obviously, David, some of the shareholder rights issues that you are bringing up will be discussed at length. In fact, in one of our, I believe, in one of our upcoming webinars on M&A activity and navigating the COVID-19 crisis. So I hope everyone who is joining on this webinar will also join that one. But on the specific disruptive nature of the pandemic, Gautier, a lot of the things that we have taken for granted, and we're not saying anything that people who are joining the webinar rather than physically at our office, either in Paris or New York, don't already know. It upends our expectations about transportation, about physical proximity. How has that impacted, in the cross-border context, things like residency and jurisdiction of effective management and transfer pricing? How are you seeing people grapple with these issues?
Yeah, the residency is clearly an issue. It's an issue for both companies and individuals, but hopefully that issue will remain mostly theoretical, at least in most cases. I think it is true that with respect to companies, certain countries determine their place of residence based on where the companies are managed and controlled. And in doing that, you have to look at where the top management make the decisions, where the board meets, where the company directors reside, etc. In practical terms, and all will depend on whether the shutdown will end soon or will last a significant part of the year. But in practical terms, if the situation remains for a long time, certain companies might face residency issues, and in worst cases, they might be denied the residence of their home country, or attributed the tax residence of the country where the top management individuals are stranded during the crisis. But if the crisis is temporary, as everyone would expect, and if things comes back to normal at some point during the summer, for example, this exceptional period should normally not have a true impact in assessing tax residence. And this is because in determining tax residence, one should focus on structural elements rather than on conjunctural circumstances, and also this applies for the characterization of PE's permanent establishments, which must have a certain degree of permanency. And the thing
actually, Gautier, could I jump in there? I mean,
Yeah.
I do think that your point is well taken on overall residency, which in a managed and controlled jurisdiction usually depends on where board meetings take place. You would think that either there'll be an exception or you'll be able to work it out somehow that you don't mess up the tax residency of the company. But PE might be a little bit more of a micro issue. So suppose an important front office person is just stuck in a wrong jurisdiction and they're doing a whole bunch of sales calls from the wrong jurisdiction from their home. That may create more of a question that's a micro question rather than a macro question. How do we deal with that, given the fact that there are so many jurisdictions where that person might be?
Well, no, of course, it has to be monitored and followed on a case-by-case basis. Interestingly, the OECD has just issued a sort of guidelines to all OECD countries, and without going into the details, the OECD says that what I've just said, which is that in order to have a permanent establishment somewhere, you have to have some kind of permanency and setup, which is not going to be sort of purely temporary. And in these exceptional circumstances, and to the extent, of course, this is not going to become a norm over time, teleworking from home should be disregarding in assessing tax resident and PE status. And that's what certain countries have already said, like Ireland, the UK, France this morning, Jersey, Guernsey, Australia. Of course, you might have, various, positions, and for example, HMRC, somewhat sort of disappointingly, they have provided some sort of vague words about flexibility under the existing rules. The expectation is that they will take a sort of holistic view of the facts and circumstances of each case. But of course, you never know, and it might be that certain countries might follow a different path and try to assess taxes based on a deemed PE status or a deemed permanent home for individuals, because individuals are in the same kind of difficult situation potentially. And this is why I think a lot of companies remain concerned, of course, and have decided to follow and monitor closely the situation during that period.
Ron, I go to you. You brought up a very important point, which is that we sometimes think about companies or boards in the abstract as if this incorporeal person actually exists, but actually it acts through real human beings, real individuals who are very much affected by this crisis, as we all know. And these individuals have, in addition to their impact on the company's tax residency or PE, they themselves may have their tax residency issues surfaced in this crisis. And David, I know that that's on the individual and the state front, that's something that you have been thinking about a lot lately.
Thank you. It's interesting. In the U.S., people often have a misconception as to what counts towards residency and what does not. Many people understand that for non-resident aliens can be treated as resident aliens depending on how much time they stay in the United States, and if they stay under a particular day count every year, they can avoid establishing or being treated as a U.S. tax resident. And there are some rules that allow you to exclude days that you're in the United States inadvertently. So, for example, if you come to the United States to seek medical treatment, there's no exclusion for those days. That counts. But if you're otherwise in the United States and something happens and you're hospitalized and you need to stay for medical care, those days can be excluded. It's a question as to what happens if you yourself are okay, but because of the COVID pandemic and the reaction of the government authorities, as I said, you're stuck here. Well, under the current rules, there's nothing that says that you get to exclude those days. I think there are people have already kind of raised this issue with the service and requested relief for people who find themselves in those circumstances. But to this point, the service has not responded. So, depending on the circumstances of that individual, how much time they may have been here in the prior years, and how much time they've been here, and in 2020, and the length of disruption of life due to the pandemic. As of now, I think there is a risk that people will be treated as residents.
Right, David. I think you were breaking up a little bit at the end, but I think the main thrust is that there are some good authorities for people who are treating medical treatment, but in the current circumstances, when you're stuck here for reasons perhaps related to family members and so on and so forth, the issues are less clear. And I think just like what Gautier said, I think the governments are developing their responses just as we are, as individuals are. And so some of that remains a little bit unclear. Thinking a little bit more long term than the residency issues during the pandemic, does this also cause people to rethink their transfer pricing or internal pricing structure? Because Gautier, obviously, it would be great to have someone as the risk taker in a favorable tax jurisdiction that is making a lot of profits. But in the current environment, the profits may very well turn into losses.
Right. One issue which will certainly come up has to do with a sort of change, radical change of a paradigm. Transfer pricing policies which were designed to allocate profits are now going to be focused on how to best allocate losses. And there might be, we'll see, but there might be a tension for those routine functions like baseline marketing or distributions functions, which are profitable because they charge their services on a cost-plus basis. You know, the question it might be going forward whether such functions are going to be exempt from all the sort of adverse effects associated with a crisis, or are groups going to consider that it's fair to assume that they will need to share, that these functions will need to share the overall burden of the of a disrupted economy, and more generally, in a world where the tax authorities are going to look for resources, the protection of their taxing rights and their revenues is going to be key, and one can expect that there will be prompt to challenge any type of attempt to push down tax losses in profitable jurisdictions. So we're going to see quite a lot of activity around transfer pricing models and how to allocate functions differently in the future. And this is again going to be quite of a discussion with the tax authorities, and this is already going on, right? For example, there are a number of management services agreements which are currently affected by travel restrictions, and so no doubt that the pricing of these arrangements may need to be reconsidered, at least as long as the current restrictions remain in effect. Just like for similar arrangements with third parties, which are currently being renegotiated or potentially being renegotiated in the current circumstances. One difficulty, yeah.
I was just going to jump in, Gautier. I mean, I do think that your point about the tax authorities being very unhappy with what's about to happen is, I can definitely see that occurring, because what they've been asked to tolerate so far is that the residual risk taker, the residual profit maker is in a tax haven. And now they're going to say, okay, well, that's good. Now the residual loss maker is in the tax haven. That's good for me. And the taxpayer is going to say, oh, no, I changed things, right? I don't have that structure anymore. And the tax authorities are going to be very, very skeptical about that. So I think that we're in for a lot of fighting.
Right. There is another point, another topic which I think, which has long been discussed and which is going to become even more popular in a global context, where many industries are going to accumulate a huge amount of tax losses. And that topic relates to the potential double taxation on cross-border flows of capital, including intra-group flows of capital. This is an irritating problem which is derived from the cost generated by withholding taxes, which are paid on passive income earned by loss-making taxpayers, such as dividends, interest, and royalties. And this is because tax credits may only be used to offset the tax due on the income, which has generated the credit. And so if there is no tax because the company is loss-making, the tax credit is just lost, and it cannot be imputed in the future. And in a treaty context, it's particularly annoying because tax credits are normally provided in order to eliminate double taxation arising from withholding taxes levied at source. But for loss-making companies, there is no relief in this kind of situation because passive income continues to be subject to withholding tax in the source state, while the corresponding tax credit is going to be of no use in the resident state. And so this problem is important. It's going to be even more important in that new world that we're going to see. It has attracted a lot of attention in Europe and has been partly solved in the EU because now withholding tax due on dividends paid to loss-making taxpayers have been held, contrary to the treaty. So this is going to be very helpful going forward, and I'm sure similar sort of challenges will come up in other situations for other types of income, and maybe into other jurisdictions around the world too. So that's a very important point in a loss-making environment.
And one of the areas, in fact, that I think we should think about whether losses would be orphaned away from the potential gains and cause these dislocations is in capital markets transactions. I'm sure there will be a lot of restructuring of debt that is going to happen. And David, do you want to comment on that?
Not surprisingly, people are expecting a wave of restructurings coming, and I think you can see that really in two contexts. One is the obvious, which is that companies that are really in trouble and need kind of significant changes to their capital structure in order to survive. Anything from full-blown restructuring where debt is equitized to other changes to their debt that in ways that will allow them to weather the storm. But you also have situations where you have companies that are not necessarily immediately threatened and are still viable, but their debt is trading down, and they view this as an opportunity to buy in some debt cheaply, understandably so. And sometimes that's the company itself. Sometimes it's a portfolio company of a private, of either a private equity firm or other institutional investor that similarly has the opportunity to buy in debt on the cheap. And obviously, both of those situations present in some sense similar, but in some ways slightly different sets of tax issues, both for the issuer and for holders, in terms of discharge of indebtedness income. When does that when and how does that come into play? The treatment of the holders, will holders recognize losses in connection with an exchange, or is it a deferral transaction? And then going forward, to the extent there's a debt for debt exchange, does that somehow change the the accrual of interest expense for the issuer, both in terms of the quantum and are they somehow kind of getting themselves into a whole different set of issues by creating a HIDU issues? And I think these are these are complicated analyses and will change depending on the particular facts and circumstances, both of the issuer's facts and the economic state that the issuer is in, and precisely what sort of changes, what debt is being modified or being changed or exchanged, and what are the extent of the changes being made. So I mean, these are I think sometimes very complex analyses in situations that are fluid and sometimes urgent, moving very fast, particularly when you have companies that are really in turmoil. And I think to a certain extent, from the tax advisor side, those are challenging only because things are moving quickly and people need to decide things quickly.
That's right. And are there things, again, in this particular crisis that's different from other crises? Obviously, COD, HIDO, which is a debt that pays a very high coupon without PIK coupon without cash. These things are common to other crises and common rescue situations. Are there specific things about this pandemic that would cause us to say, well, we have to look at that again? And one of the things I was thinking about, for example, is that the particular type of disruption that we are experiencing in this type of crisis actually does halt some business activities almost completely. And at least in the US, for NOL utilization, and certainly for normal M&A deals, you need to satisfy the requirement that the business is continuing. And in fact, I think in Europe as well. And that may be something that we have to review again in light of the particular type of disruption that we are experiencing. There are helpful authorities on past disruptions of this kind. And based on what Gautier was saying about residency, at least when we're assuming that the crisis is temporary, the government seemed to be sympathetic. But are there other areas such as these that we should think anew about? I think that's a question that we should consider, and probably for people who are interested in more of this topic, we have two upcoming discussions on finance and restructuring capital markets in this webinar series. So we hope everyone will join us for that as well. And are there other things such as negative interest rate that could happen that, again, people have sort of put to the back of their mind for a while that we should start thinking about again?
I mean, let me spend 2 seconds on negative interest rates. Hopefully we won't have to spend more than 2 seconds. But we are getting closer in the US, and obviously other jurisdictions are already there. And I think the question in my mind is, our authorities don't really work our existing tax authorities don't contemplate that fact pattern very well. And so we have some rules for amortizable bond premium that try to get things where they should be down to zero. So if you issue a bond at 1%, but it's at a premium, and so there's an amortization of the interest expense and interest income, you're allowed to match them up down to zero, but you're not allowed to match them up after zero. And so there is some helpful authority, but it doesn't go far enough. The other stressor, or perhaps it is an opportunity, is, as everyone is well aware in the U.S., 163J, which maybe the pressure got taken off a little bit on 163J after the CARES Act, but 163J puts a premium on what is interest income and what is interest expense. And it's very different if you just have a loss as opposed to interest expense. It's very different if you just have income compared to interest income. And so these kinds of situations where you're trying to analogize to imperfect authorities, there may be an incentive to try to put your thumb on the scale when you want something to be interest, to treat it as interest, and when you don't, then not. And so that's going to be a hard conversation.
Right, and a lot of these authorities really, I think, are predicated on the notion that negative interest rate would not last very long. Certainly the mathematical assumptions behind it, because if we actually extrapolate negative interest rate into the long term, if the crisis, contrary to expectation, were to last longer, I think that would append how we calculate PV, how we calculate tax attributes, going back to the first part of the conversation that we were having about just normal M&A activity, and certainly to Gautier's point, to transfer pricing and cross-jurisdictional planning. We have about 5 minutes left. So with that, I want to perhaps ask the panel to give their thoughts on the prospect for legislation, the impact of recent changes, and maybe on the impact on pre-existing projects such as the OECD Pillar 1, Pillar 2, and how they might be impacted by this particular crisis. So maybe Gautier, you could begin with that.
Yeah, as everyone knows, the OECD has received a mandate from the G20 to make proposal in order to address the tax challenges of the digitalization of the economy. The OECD has released a public consultation document which proposes a sort of entirely new approach to international taxation, which is called the Pillar 1 approach, and which basically reallocates more taxing rights in favor of the market jurisdiction, basically. A more detailed report should be issued by the end of June, and the goal being to possibly reach a political consensus in the G20 meeting, which will be in early July in Berlin. For the moment, the OECD has issued mid-March, I think, a press release announcing that despite the crisis, work continues and meetings among country delegates are being held remotely. However, it's quite clear that the process is not moving at the normal pace. Zoom meetings with more than 300 participants who are supposed to interact with each other are quite heavy to organize and extremely difficult to hold, apparently. And so it's likely that the work is going to be delayed. However, the issues raised by the digital economy are not going to go away. On the contrary, and this is one big thing of this crisis, which is that it demonstrates quite vividly that our phones and computers are quite important, and as a result, the present crisis will have a clear and deep accelerating effect on the digitalization of the economy. So the tax challenges raised by that are going to be even more important in the future. And all these issues, by the way, are not confined to highly digitalized business, the Googles, the Amazons, the Facebooks, and the Apples. Of course, these companies are going maybe to come out of this crisis stronger than ever. But with respect to the OECD proposal, Pillar 1 is not limited to those businesses. The US have much insisted to include other more traditional businesses who should also attribute a bigger portion of their taxable basis to market jurisdiction. And this is how the proposal has been extended to consumer-facing businesses, whether or not they are digitalized, And the problem the OECD is facing now is that once you have allocated a portion of your profits to a given market jurisdiction, you have to extract that profit from other jurisdictions and, more importantly, from other entities in the group. And you have to identify precisely the entities which are going to contribute in terms of profits. And in the current environment, with a huge pressure on budgets, this exercise is going to be extremely challenging, including for the businesses and the traditional businesses with a highly complex organization and a highly complex value chain. And that's why basically the US have proposed to make the system optional, but that proposal raises huge acceptability problems for many countries because it means that the taxpayer may have a say in the allocation of its taxable basis across the globe, which raises obvious political issues and also legal issues, constitutional issues in many places. And that, all this, is extremely difficult and is even more difficult in the current environment. The U.S. Council for International Business have declared that the OECD should, postpone its efforts on Pillar 1 because at the moment both governments and private businesses just have spent all their time and efforts in dealing with the crisis. So what we're seeing now is that countries opposed to the project, and there are quite many countries which are, doubtful, clearly view the crisis as a sort of opportunity to slow down the process and potentially reopen the discussion on fundamental points. So we'll see. Future will tell. It's difficult to say what's going to happen on this front.
Okay, with that, I think we're actually coming upon the end of the hour. I think we explored some very interesting topics. We welcome everyone to continue to explore these topics with us in our upcoming webinars on crisis management, M&A, capital markets, and debt restructuring. We hope you enjoyed our discussion, and we hope to hear from you because these are the topics that we love to deal with. These are difficult topics, and this is what we at the SNC Tax Group actually love to sink our teeth into. And we hope you're well, and we hope that everyone near to dear to you are well and healthy and safe in this time of crisis. Thank you.